happy to be your next victim. I'll just apologise in advance if one of my children turn up. They've already made a guest appearance, but luckily I turned my camera off. They've just got home from school and they're very excited because it's the 1st of December. Happy nearly Christmas to everybody is what I'm saying. So first of all, look, congratulations to the team on the work, because I think there's a really interesting set of principles here. And the homework, Burkhart, that you set us was to draw out one thing that we really liked, and one thing that maybe was a moment of contestability, some conversation. And there's lots of things I like in the work that I've read so far in the draft. But if I was to boil down the things that really home in, that I really like, which I think are at the heart of some of the knottiest, wicked questions, which I think, actually, Jacob, you described a particularly wicked question, which is, what is the standard of threshold of acceptability here? Is it needs to be better than human, or can be like human is good enough? And I think it's not actually a particularly straightforward dilemma to solve. But the issue I want to really draw out here is the tension between the immediate gain of having something that serves an immediate need. And that could be an immediate need in a private-to-private interaction, a business interaction of some description, or indeed in the public sector, so expediency of criminal cases, or at least mapping out where you might use your resources in an ever-decreasing public spend scenario. With the more longer term view, with a more aggregated view of those actions being multiplied, or wider societal considerations. And here actually what we see is, in a way, a lightning rod, a shining down on this particular tension between the immediacy of the gain, but the longer term or the wider implications, which may not necessarily be, if you're dealing in a private interaction, your client's concern. But it may be, if you're a lawyer, for instance, as a servant of the court, it ought to be within the consideration. But the rub here is, how do you make it something that is relevant to your clients, and how do you square that? I think that's an incredibly, both I love it and I'm very troubled by it, because I don't really see an easy way to surpass some of that tension. The one area where I think actually I take a more positive view, I think, and I maybe have evolved my own view on this, is the risk of as you described it, Burkhart, earlier, the ossification problem. So if we don't test the law regularly enough, does the law move with societal values? Now, I do think there is a distinct risk at that. I also, having been at the cutting edge of kind of public policy reform and campaigning, know that lots of people still fight a case when there's a principle at stake that we care about. Now, that obviously is skewed towards probably more public law type questions than maybe you'd get in a corporate environment. But I do think maybe there's less of a risk of that really ossifying the values in public law than sometimes we bring to bear in these sorts of conversations. I hope that I'm right, but there certainly is a risk, but maybe not quite as significant. So there's my immediate reactions, but there is plenty more in the report that I'd love to talk about as we go through.
And hopefully we will. I mean, you're absolutely right. It was one on both of these points. They're really, really interesting. Ethics becomes relevant not when we all agree what we want to do anyway. And for that, you don't need ethics. For that, you just need not to be a bastard, if you like. Ethics principles are where the real hard conflicts are. And one of the hardest ones, I do agree, is I want to do the best for the person in front of me. And that is perfectly reasonable. And I might even bend the rules a little bit for that. As a medical doctor, pushing the prescription limits, if I make the professional judgment that that's the right thing. So on the one hand, I feel the pain of the person in front of me. And at the same time, I'm also aware of, I should ask myself the Kantian question, what would happen if everyone is doing this? Can I live with that in the long run? And that is also to go back to Jacob, where it becomes difficult. How do I actually operationalize that conflict? How does this help me? And to a certain extent, that's where we punt the buck, if you like, to the professional bodies, because they always had exactly that conflict to resolve to a certain extent. So things like, yes, you on behalf of your client, you can write aggressive letters, but there comes a point where writing an aggressive letters becomes an inappropriate threat, especially if the receiving end is not legally trained, and it might appear that you are making claims stronger than you should. And that's where the very difficult, very gray boundary is going to be. And I think the law societies will have to draft rules that are similarly contested, similarly problematic for resolving exactly that problem. The ossification problem is also quite interesting. And you're right, to a certain extent, it's an empirical question. Will that happen? Will that really lead in the loss of litigation? Going back to Jacob, it might matter who uses these systems. I would be more worried if the legal aid board is using them to determine eligibility for legal aid than a lawyer who has other means of financing, for instance. And the other thing as well is important, and I think that is how we try to frame the rule, think about this and how you mitigate it. So one mitigation strategy here, as you indicate, might be to leverage technology for new forms of financing litigation. And obviously there are ideas like that around, and they pose their own ethical issues, crowdsourcing litigation, for instance, things like that. So we shouldn't assume that things are just like that and we only change one parameter. It might also be, yes, they have that tendency, there's a potential, but by making changes in the legal system elsewhere, we might make it easier, financially more viable for people who really believe in something to then bring it aboard. And again, I would also say, one of my concerns is we shouldn't glorify the past and we shouldn't imbue the present ethical value just because we are used to it. Obviously, our justice system has massive problems. Obviously, some of these issues of unfairness permeated, and we do not want to continue with them. And the ossification, one place where you see that is a way, not so much in the UK, but in the US, for instance, plea bargaining is used not to bring cases to litigation, and therefore certain types of evidence gathering are never tested. So we know that sort of thing happens. It happens without technology. One of the questions is, to what extent should I, as a technologist, feel nonetheless responsible when I might contribute at least to that? But yeah, thanks a lot for both of your points. Wendy, I pass it on to you.